Nearly 6 years after the controversial demonetization of high-value currency notes of Rs 500 and Rs 1000, a constitution bench of the Supreme Court today began hearing a batch of 58 petitions challenging the November 8, 2016 circular issued by the Ministry of Finance that set the ball rolling. The 5-judge bench, comprising Justices Abdul Nazeer, B.R. Gavai, A.S. Bopanna, V. Ramasubramanian and B.V. Nagarathna, had earlier wondered if anything survived in the issue after all these years and whether the exercise had become merely academic. On the previous date of hearing, and we have made a video on the previous proceeding as well, the link to which has been given in the description box below, the Supreme Court had observed that it will first examine whether the petitions challenging the demonetization exercise have become academic in nature. The bench today also said during the hearing that it wants to see the documents relating to the RBI board meetings ahead of the announcement of the demonetization exercise by the centre. During the hearing today, the Attorney General R. Venkataramani and the Solicitor General Tushar Mehta attempted to convince the Supreme Court of the futility of examining the question at such a belated stage. Mehta suggested, and I quote here, the individual issues and the problems may be taken care of on the administrative side. There is no need to waste the time of this constitution bench. However, the bench was unwilling to agree and permitted senior advocate and 4-time finance minister P. Chidambaram to make his preliminary submissions. This was despite the top law officers trying to persuade the court to take up the matter on another day instead. While the Attorney General for India R. Venkataramani and Solicitor General of India Tushar Mehta repeatedly asserted during the hearing today that the issue has become purely academic in view of the passage of 6 years, senior advocates P. Chidambaram and Shyam Devan contended that the validity of the government's decision was still open to challenge. The senior lawyers appearing for the petitioners today raised the argument before the Supreme Court that the government lacked the power to cancel the currency notes through an executive order and emphasized that the issues in this matter hold relevance for the future as well. Persuaded by the petitioners' arguments advanced, the Supreme Court bench today observed that the issue may not have become academic. The bench also said that it was the duty to answer the issues referred to it by the Constitution bench and that it has to answer them one way or the other for posterity. Pertinently, during the hearing today, a senior advocate Chidambaram also highlighted the absence of a comprehensive affidavit filed either by the Union of India or the Reserve Bank of India. Agreeing with what was pointed out by Chidambaram, Justice Nazeer of the Supreme Court asked the Union, and I quote here, "Can we assume your pleadings are complete in this case? There may be some factual differences also in some of the cases. Somebody should take serious note of this from your side." The Attorney General in response confessed that he was finding his footing after recently being appointed. He apprised the bench that he would look at these cases where the pleadings were different. Accordingly, Justice Nazeer today instructed that both the Union of India and the Reserve Bank of India should file a comprehensive affidavit which the court will take as a response to all these cases. Chidambaram, during the course of his submissions today, pertinently emphasized the reluctance of the central government to produce crucial documents such as their letter to the Reserve Bank on November 7th, the agenda of the board meeting of the Reserve Bank conducted on the very next day, as well as the resolution passed by the Board of Directors. He reiterated his demand, and I quote here, "If necessary, we will file an application to summon these documents, but in a matter of this nature, the government should fairly place these documents before the court. The government may be directed to place these 3 documents on record." The Attorney General at this point quickly interjected and said, and I quote again, "If and when necessary, whether they will advance the course of all these arguments." Justice Nazeer, however, unequivocally stated that the documents in question must be produced before the Supreme Court. He underscored, and I quote, "We want to see them, you cannot keep them away from us. Also file a comprehensive affidavit." Justice Nazeer also pointed out that the petitioners were questioning the power of the central government to invoke Section 26 of the Reserve Bank of India Act to demonetize the currency notes. Chidambaram today argued that Section 26 subsection 2 gives power to the centre to cancel only certain series of currency notes and not the entire notes of a denomination. Taking note of these arguments, Justice Nazeer told the Attorney General of India, and I quote, "The sheet anchor is Section 26 subsection 2 on the recommendation of the central government. Show us where the recommendation of the central government is. Thereafter, where is the consideration by the Reserve Bank and what was your reply? These are the three things you must answer on facts. Secondly, how to interpret the word any in the provision. Chidambaram says, read it down or in the alternative, quash it. You must address these in your pleadings." The Attorney General, on the other hand, tried to underscore the importance of Section 26 of the RBI Act in the economic and financial architecture of the country, to which Justice Nazeer said that the Union should put all of this in writing in the counter affidavit. After receiving the court's permission to argue the matter on merits, Chidambaram today gave a broad overview of his submissions. First, he argued that the power to demonetize all series of banknotes of any denomination by issuing a notification in the official gazette was not available under Section 26 subsection 2 of the Reserve Bank of India Act, and accordingly it must be read down. Otherwise, the power conferred under this section would be unguided and uncanalized, and as such subject to the discipline of Part 3 of the Constitution. The senior counsel today also criticized both the decision-making process as well as the recommendations tendered by the Reserve Bank of India as deeply flawed in nature. Furthermore, the government set out false objectives to justify the demonetization exercise. Chidambaram also argued that when weighed against the horrendous consequences, the policy would fail the test of proportionality. Finally, he explained that the Supreme Court had wide powers to grant declaratory reliefs, lay down the law and mold the reliefs. The matter is slated to be heard again on November 9th. Thank you. I'm Nagarathna for LiveLaw. Keep watching LiveLaw for more such updates.